You're listening to People, Places, Planet, the official podcast of the Environmental Law Institute, a nonpartisan, nonprofit research and education institute making law work for people, places, and the planet. If you enjoy the podcast and want to support our work, consider donating at eli.org/donate.
Thanks for joining us on today's episode of People, Places, Planet. In today's episode, we're bringing on two of our own ELI staff and three guests to talk about Professor Seema Kakade's article in the Environmental Law and Policy Annual Review, and originally published in the American University Law Review. The article is titled A Contractual Relationship with Environmental Justice, and in it, Professor Kakade proposes that environmental nonprofit organizations should establish environmental justice transactional practice groups to provide legal services for community groups that contract with corporations over facility siting and permitting. She also proposes that their efforts should include developing a database of agreements, which serves as a starting point for developing innovative contractual provisions. I'm going to introduce my co-hosts in a moment, but first, I'd love to introduce our three wonderful guests. Professor Seema Kakade has been a professor of law at Maryland Carey Law since July of 2017. Her clinical practice focuses on environmental justice matters in the Mid-Atlantic region. Her areas of focus include clean energy, infrastructure, environmental permitting, and pollution. Maia Hutt is a senior attorney at the Southern Environmental Law Center. Her work focuses on the environmental and public health impacts of swine waste pollution in North Carolina and on industrial animal operations and solid waste management at landfills. Maia also works to promote federal, state, and local policies that treat rooftop solar customers and independent solar companies fairly and help accelerate a clean, just energy transition. Shanika Amarakoon is the vice president at the Eastern Research Group, better known as ERG. She has over 25 years of experience as an environmental engineer and policy analyst for federal and state agencies. She excels at leading analysis related to community resilience, circular economy, renewable energy. Her work in these areas includes analysis and outreach to low-income and under-resourced communities, including rural communities. So now I'd like to introduce you to our two guest co-hosts. First, we've got Mara Pusic, who is a research associate at ELI, and Linda Breggin, who you might be familiar with, who is a senior attorney at ELI and director for our Center for State and Local Governance. She's also a lecturer in law at Vanderbilt Law School. Now I'll pass it off to both of you to give our listeners a little bit of context about ELPAR and launch into our discussion about Professor Kakade's article.
Well, thank you, Dara. We are delighted to have our guests here today to talk about a contractual relationship with environmental justice, an article originally published in the American University Law Review. But before we jump in to discuss this article, just a little background here. The article was selected for recognition in this year's Environmental Law and Policy Annual Review, or ELPAR, as we call it. ELPAR is a 17-year collaboration between ELI and Vanderbilt University Law School, in which we seek to identify some of the best ideas in the environmental legal academic literature each year, and specifically those that offer creative and feasible policy or law proposals. So first, a key objective of ELPAR is to bring these ideas to policymakers and practitioners who typically don't have time to read law review articles, or at least I certainly did not have time to read articles with hundreds of footnotes when I was in those roles. And then second, we also want to recognize academics who take their work a step further than is traditional and translate their theories and ideas into practice. So basically what we're trying to do here is bridge the gap between academics and practitioners and policymakers. And we take some of these articles and we republish them in the August issue of the Environmental Law Reporter each year, but in a condensed or shortened form that's much easier for busy people to read. We also host panel discussions and webinars and podcasts like today's to highlight the proposals in the articles that we select. And I should say a key aspect of ELPAR is that the articles are reviewed and selected as part of a class at Vanderbilt Law School that I co-instruct with Professor Mike Vandenberg. The students review and present and discuss articles in the class, and they engage with our expert advisory committee. It's a very thorough process over the course of 2 semesters. And to give you a sense of how we selected the article we're talking about today, I want to hand it over to Mara.
Thanks, Linda. As Dara said, I am the ELI Research Associate who works on ELPAR, and among other responsibilities, I work closely with Vanderbilt law students in supporting their efforts to select articles. I'd like to share a brief overview of the ELPAR process. The Vanderbilt law students start with a review of all academic literature published in the last year, drawing from the top 100 general law reviews and all of the environmental journals. They perform a Boolean search in Westlaw to collect any article that includes the word environment, which produced about 1,500 articles this year. They then sift through these articles and keep only those that address the natural environment as opposed to other contexts, which this year resulted in approximately 500 articles. Students then screen through these articles to identify articles that address 1, an issue of major importance to environmental quality, and 2, that offer a law or policy proposal. Articles that satisfy the 2 threshold criteria then get evaluated using ELPAR's 4 evaluation criteria: persuasiveness, impact, creativity, and feasibility. Ultimately, they identify what we call the top 20 articles through extensive class discussions. We post the top 20 list of articles on the ELPAR website each year. This year, Professor Kakade's article was one of the top 20 articles selected.
As you can tell, it's quite a process to get selected for ELPAR. So I just wanted to give that context. And now let's get started. So, Seema, in your article, you focus on the relationship between corporate polluters and impacted communities. And you propose that environmental nonprofit organizations play a more robust role in strengthening what you collectively refer to as corporate community agreements, but also known as community benefit agreements or good neighbor agreements. Can you start by just telling us more about these types of contracts, including when are they used, what are they addressed, and how do they advance environmental justice?
Thank you so much, Linda, for the question. I do want to just quickly say thank you to ELPAR for this great recognition. It was actually wonderful to hear about the selection process and just really appreciate the recognition for the piece. To answer your question, Linda, I'm going to just say that big picture, what I'm talking about when I'm talking about corporate community agreements are really agreements that are used when a corporate entity, often a developer, provides benefits to a community in exchange for the community's support, or at least to resolve their opposition to the corporation's project. So they're used in a variety of different kinds of contexts. The corporation might be involved in a real estate development project, for example. The corporation might be involved in a mining project, an oil and gas project, a renewable energy project, a carbon removal project, a manufacturing project. There's lots of different kinds of environmental sectors that we see these kinds of agreements coming up. My piece is specifically focused on these kinds of agreements as contracts. So I do want to recognize that community benefits between corporations and community groups can come in other forms that are not contractual in nature. They can come in forms like direct payment to communities. They can come in forms like setting up trust funds for communities to tap into the future to pay for specific kinds of benefits. And when I say benefits, what I'm really talking about is a wide range of things that a community might want to see. A community might want to see that there is some kind of new school in their community, or new infrastructure project, or new park. That might be a benefit to the community. The community might want to have labor benefits as a result of the developer building a new manufacturing facility. They may want to retain local jobs, for example, as a benefit. So there's lots of different kinds of benefits that can be memorialized in these agreements. And what I'm looking at in the paper is the memorialization in an agreement that takes the form specifically of a contract.
Seema, thank you for giving us that context sort of in terms of where these fit into the big picture. I'm wondering if you can tell us a little bit about how these contracts advance environmental justice in all of the forms that you mention in your article.
Absolutely. I just think that these kinds of contracts or agreements really have potential to address multiple forms of environmental justice. If you think about, for example, procedural environmental justice, which really involves making sure that communities, particularly vulnerable communities, marginalized communities, disadvantaged communities, are able to even get to the point in which they can discuss what benefits they might want to see out of a developer or a company coming into their community. Even being able to get to a table to discuss that, being able to be involved in negotiating for themselves is a huge amount of process involved, which I think really lends itself to achieving significant progress in procedural environmental justice, as an example. I also think that depending on the kinds of benefits that may play out in any negotiation of an agreement or a contract like this, there's opportunity for addressing what we might refer to as distributional environmental justice. We can really think about existing structures where there are challenges on where we distribute, for example, pollution, where we distribute benefits like parks, where things are located. We can imagine that in entering into agreements between communities and developers and thinking about the future, we can redistribute and reshift where people have burdens and where people have benefits to the environment around them. We can also think about these kinds of agreements as addressing other aspects of environmental justice. So thinking about things like restorative or reparative justice, which is repairing harms that have been done in the past. We see this, for example, in situations involving the mining sector or in situations involving companies that may not be brand new to the community, but may be expanding an existing facility where there might be long-standing relationship between that company and particular community groups. And now we want to think about repairing that relationship, repairing harm that may be done, that may have already been done as a result of that corporation being there. So we can think about it in terms of reparative or restorative justice as well.
Thank you for walking us through the ways in which these agreements can advance environmental justice. And I want to hand it over to Mara now because I know she has a question about your proposal.
Seema, in your article, you explain that you suggest tapping environmental nonprofit groups to develop environmental justice practice groups. Could you explain a little bit more about why you believe they're well positioned to take on this role?
I think that environmental nonprofits are uniquely positioned to take on this role for a number of reasons. So if you think about who might make sense, it certainly is not the corporate entity. It certainly is not the community group. These are the two groups that are trying to come together to make an agreement. And so it really needs to be somebody other than those two parties. So in thinking about something other than those two parties, why specifically environmental nonprofit groups? Frankly, I think they have the skill to do it. I think they have the skill to do it because of the practice that they already are engaged in, which tends to be very litigation heavy. And in the process of litigation, we see often that litigation settles. So I make an argument in the paper about settlement agreements being somewhat akin, or at least related to, the idea of a contract and have a lot of similarities to contracts. And so to me, they're uniquely positioned based on the skill that they already possess. Environmental nonprofits, and particularly environmental lawyers in environmental nonprofits who often have the experience of litigating and settling. Environmental nonprofits, typically organizationally, are looking to serve the greater public and specifically are looking to serve the communities. And we've seen a transition over the course of many, many years and really decades to see a lot more emphasis within environmental nonprofits on environmental justice specifically.
Well, that makes a lot of sense, Seema. And before we engage our wonderful other guests to get their reactions to that, I do want to make sure we've touched on all the parts of your proposal. For example, in your article, you also propose that environmental nonprofit organizations focus their transactional practices in part on the design of corporate community agreements. And you suggest that contract design innovation could take corporate and community contracts to a new level. Can you tell us why innovative contract provisions could be important and what might they address?
Absolutely. So, if folks that are lawyers in particular that are listening may recall their 1L first year law curriculum, contracts is kind of a big deal. It is a 1L required course. It is a whole discipline and a whole field by itself. And there is a lot happening in that space. And so my suggestion is that environmental nonprofits, while areas like settlement agreements in the context of litigation resemble contracts, I do think that contracts are a distinct field. And as a result, I think there is a lot of potential to really tap into the contracts field and what's happening in that space. So we can think about things like, why even enter into a contract? How do you deal with short-term contracts versus long-term contracts? How do you deal with ancillary contracts that might be related to your original contract? How do you deal with modifications to contracts? I mean, the list goes on, Linda. There are multiple questions that are very present in the contract field. And a lot of them have to do with contract design, contract implementation, and a lot of them also have to do very much with the growth in technology that we have seen in the contract space, which also lends itself to a significant amount of conversation and discussion in the space of things like data privacy, confidentiality, which is a whole area of the contract law space as well. And so what I'm really suggesting is that we think about contract and contract law development as an additional tool in the toolbox for environmental justice. And in part, what I'm hoping to see is that this concept around a transactional environmental justice practice group would match what we're seeing at the corporate sector, which often have separate transactional groups engaged in contract law design and contract law development.
Thank you, Seema, for explaining that. It took me back to law school a little bit. Well, we have more questions for you, but I want to hand it over to Mara to engage our guests.
Maia, I know SLC does some work with communities, and hearing Seema's pitch for contracts, I wanted to ask if you've worked on any corporate community agreements.
Thanks so much, Mara. So I work at SCLC with a number of communities across our region. The focus of our work is really to protect the basic right to clean water, clean air, a livable environment, and a healthy environment for all. And that necessitates working closely with communities. The corporate community agreement that I've worked on most recently really falls into the category that I think Professor Kakade was referencing as being, more settlement adjacent rather than pure contract. And so I want to preface it with that. But that agreement that we just negotiated at the end of last year was with a client who is another local environmental justice group called the Environmental Justice Community Action Network. And that agreement in particular involved two elements. And one was a kind of traditional Clean Water Act consent decree. And then one was a community benefit agreement structured more like a contract. And those agreements were with GFL, which is a major landfill company that works across North America. And the goal of both of those elements, but specifically of that community benefit agreement, was to address the longstanding impacts that the Sampson County landfill, which is the largest landfill in North Carolina, had on this particular community known as the Snow Hill community in Roseboro, North Carolina. And that community is a rural, predominantly Black and Latino community. The folks living there, a lot of them are descended from formerly enslaved people that moved to that land after they were freed. And they have been there for a very long time with their families. And this landfill that's been there for 53 years now really altered the course of these families' lives and had a lot of impact, not just on the environment, but on public health and economic opportunity.
Thanks. That's really interesting context for your work. And I'm curious, just what is your general reaction to Seema's proposal, and how has your work with the Environmental Justice Community Action Network and others, for example, informed that reaction? And I'm particularly interested in whether you agree that your colleagues and yourself, those of you who have litigated already and have experience negotiating settlements and consent decrees, how do you feel about focusing more on this type of work, and what do you see are the barriers or drawbacks to this approach?
I think it's a fantastic proposal. I mean, to speak personally, I really enjoyed reading the article, and it's gotten my gears turning in my head about how to incorporate more elements of contract law into our work. I think a lot of environmental lawyers think of themselves as litigators first or as administrative law experts first. But like Seema said, a lot of those skills involve settlement and having to be creative in a way that litigation and court orders can't always be. And I think specifically the remedies available in court often aren't adequate to make a community whole. And contract provides another way to get relief for these communities. And I think that's particularly true where you have communities that are experiencing not just environmental injustice, but also economic injustice and structural racism. Having the option to creatively solve those issues in a way that a court order can't, I think is a really excellent opportunity. The main barriers I'd add is that doing this kind of work with communities requires a large amount of upfront investment and upfront trust building. And so it's not enough to just develop the transactional practice. I think you have to develop those skills for attorneys and then also invest in building a relationship with the communities that allows you to credibly show up and negotiate these kind of agreements. And then the second thing that I think is really important is leverage. A good agreement that's going to get meaningful relief for community will require a company to make compromises and to spend money. Frederick Douglass said, power concedes nothing without a demand. And so I think it's really a matter of both developing the transactional practice skills and then pairing it with the ability to litigate and to build those relationships in a way that makes litigation or negotiation a possible path and gives you some credibility when you're negotiating.
Maia, thanks for highlighting all the different skills negotiators need to bring to the table. Could you tell us a bit more about how these play out? And do you share Professor Kakade's observations about the challenges communities face throughout the negotiation process?
Absolutely. So in the pre-agreement phase, I would say that that's actually where most of the challenges and effort really take place. So, as the article recognizes, communities are not a monolith. There can be multiple leaders in the community. There can be people with lots of different opinions. You know, if you ask everybody on your street how they felt about a particular issue, you probably wouldn't get the same answer. And that's true for communities that are being impacted by pollution or by the development of some project as well. For environmental nonprofits that are interested in working directly with communities and supporting them in this way, it's really important to take the time to understand what are the challenges that the community is facing and then what are the potential solutions. For example, in Sampson County, I had spent a fair amount of time working with this community on industrial animal agriculture issues. And I thought that was the primary issue that we were going to work on together. And then I kept hearing from people, this landfill is the thing that keeps us up at night. It's the thing that we're most worried about. And so to be a good community partner, and then ultimately in order to be able to do something to address their concerns, that required me to reframe the way I was thinking about the issues impacting the community. And that took years for them to get comfortable enough with me to tell me, hey, this is really what we're worried about, and to build that trust. So I'd say just that relationship building and being willing to hear out what the community wants as opposed to what does a green group want is really important. And then the other piece of the pre-agreement phase is figuring out who are you negotiating with? What is this entity on the other side of the table? And what is their history? Are they even willing to come to the table? I've had interactions with some companies that just categorically do not want to have those conversations. And then there are others that are very willing to have the conversation. And so doing your homework on that and really understanding who are the parties here and how can we fit in and be helpful and not accidentally walk into a history that's been playing out for many years before you got there. And then I think the final piece of that pre-agreement phase is figuring out what kind of leverage you have. I referenced this earlier, but in the case I've been speaking about, the primary leverage that we had was a really strong Clean Water Act claim based on contamination of drinking water and groundwater with PFAS, forever chemicals. And so that was what it took to get the corporation to the table.
So that's pre-agreement and getting folks to the table. How do you move from there?
So the next phase was negotiation. That's a piece that a lot of environmental attorneys are pretty comfortable with because they have that experience from litigation practice. And I think the most important thing is that if you are doing it in the context of litigation, you might be bound by confidentiality requirements. It might be hard to be reliably getting feedback from the community on proposals as they evolve, but you still need to make sure that you've done enough work up front to represent their interests as best as you can. And in our case, EJ Can, our client, had many members who were members of this community that was impacted, but that doesn't always mean that there's 100% overlap between the nonprofit that represents the community and every single member of the community. So just being aware during the negotiation phase that different people in the community might have different opinions on what is an acceptable outcome. And then last, on post-agreement, that is where we are right now on the project that I've been involved in. And there's both implementation and enforcement there. So for a lot of the kind of benefit that the communities we work with want, it takes a long time to get things off the ground. So for example, building a community center or creating an odor monitoring plan that's going to make sure that odors from the landfill aren't impacting communities as often. Those things take time to set up. And if you have the best agreement on earth, if it's not enforced and someone's not keeping an eye on it, it's not doing a lot of good. That's a piece where organizations like SCLC and other environmental law firms and nonprofits can put in that work and alleviate some of the problems that were identified in the article, which is that it's really hard to do enforcement and to hold the parties accountable to an agreement.
Maya, thanks. That's really helpful in understanding how this works in practice and, frankly, the time and resources and flexibility that required. So, Shanika, tell us about your consulting work as a policy analyst for state agencies, and in particular, the work you do related to low income and under resourced communities.
Some ERG projects that we lead and that I lead in particular have done some really interesting work with state agencies. And it's because these state agencies are basically leading exciting efforts to ensure that the voices of low income and under resourced communities are represented and incorporated as part of new projects. And these more recently include clean energy and clean transportation projects. So some of our work and support have involved outreach with these communities, making sure that they are aware of the project, so raising awareness, and then doing the work to get them to the table, because often everything we're talking about with respect to community benefit agreements is shaped by those who have the voices at the table. So making sure we get a good representation of those voices at the table, and then ensuring that community interaction and engagement is meaningful versus just a check in the box exercise that we want to avoid. So we often support the engagement side, raising awareness side, but then we also look at providing communities tools and analytics that they can use or that state agencies can use to help inform the potential burdens and benefits of different projects. So these impacts or benefits could be related to economic, environmental, or social impacts. And so that could include, for example, a GIS analysis or looking at pollution data, looking at other economic data to help guide decision making.
That's really helpful. And so, of course, I'm curious, based on this experience working with states and communities, what is your reaction to Seema's proposal? Would communities benefit from the approach she's recommending? Are there drawbacks? And, of course, are nonprofits the right entities to represent these communities in these transactions?
Yes, communities would definitely benefit from this approach. I mean, this is again one tool of the toolbox. And I think both Seema and Maya have touched on the fact that as part of this process of getting NGO support for developing these contracts, there also needs to be that trust. And so it's really important to make sure that the NGO that they're working with or that's supporting this takes the time to build that trust if they aren't already kind of embedded as part of the community. There's a quote that's often used, change moves at the speed of trust. And so it's really important that depending on the NGO, the history of the NGO, what relationships do they already have existing within the community? Do they really understand the history and challenges and needs of the community? How can they understand that better as part of informing this process? And then the other part that I think is really important is making sure that the community has the information that they need. Yeah, I'm not a lawyer, I'm an engineer. So I'm always looking for somebody to explain to me in plain English, what does this mean, especially when it comes to legal requirements? And the questions of, is it enforceable? I think is a really important one. But also, making sure that there's information or as part of these agreements that they're being given measurable benefits, right? So it's not these pie in the sky kind of benefits. It's ones that really are actionable and measurable over time. So I think that's really important. And also making sure that they have access to a baseline of data and information so that they can make decisions about what maybe we need to see as part of these community benefit agreements to reduce impacts that we may not be aware of. So I think it's just really important to also look at other information and data and tools that these communities should be provided.
That's super interesting and a great segue to our next question. One of the components of Professor Kakade's proposal is for environmental nonprofits to develop a database of agreements to serve as a starting point for developing innovative contractual provisions. Do you think that this would be helpful?
Yes, absolutely. I think it's always helpful to see examples. And again, it's part of explaining this to the different communities, realizing that no community is alike and no project is alike. But having some kind of an example and certainly a database so that they can draw from different ideas as part of that as well, of different benefits that they may want to see or the menu of options that they may want to incorporate is specific to their community and the project that may impact them. So I think it would be incredibly helpful to have this in one centralized place.
So I want to shift gears a little bit and note that you grew up in a rural community. And if nonprofit environmental groups bolster their transactional work, as Seema has suggested, are there any special considerations they should take into account in representing rural as compared to urban communities?
Yes. So I grew up in a very rural community, a town of 2,000 people. And one of the limitations we have found in raising awareness of different projects and working with different community based organizations, CBOs or NGOs, is there's a very limited availability of NGOs that serve rural communities or that are located in rural communities. They're often located closer to more urban areas or other areas where there's more population density. So when you're looking at a nonprofit to work with a rural community, it's really important to make sure that they have that trust, that they gain that trust and earn it, and that they realize that no community is the same. And that certainly applies to rural communities as well. It's not a monolith. And so it's really important to understand the unique culture that may be present in that community and the fact that everybody knows each other for the most part. So that trust might even be harder to gain from outside groups coming in. So it's really important to start working with community leaders to establish that trust and listen and learn through that. And then also realize that these rural communities may have different concerns related to older infrastructure or concerns about visual or aesthetic concerns, or just concerns that they're bearing potentially a disproportionate amount of infrastructure or other siting to support more urban communities. So again, sharing that information and gaining the trust is really key and fundamental to that.
Well, that sounds like really good advice. And I'm curious, I want to give Seema a chance to respond to what she's heard from both Maya and Shanika. So I want to hand it back to you, Seema. And I do also want to ask that maybe you flesh out the concerns with this status quo that you're trying to address with your proposal. Like, why do we need this change?
I am suggesting that we need this change because what I'm advocating for is something pretty big to actually deal with the exact concerns that Maia and Shanika are presenting. So what I've heard a lot is it takes a lot of time to develop trust with communities. It's really hard to know what do you do when you've got multiple community groups. Communities aren't monoliths. So sort of that entire pre-agreement stage is huge and time consuming. There's scientific issues, there's information issues, there's trust issues. I'm also hearing that it is a huge challenge, as Maia pointed out, to be thinking about the negotiation phase. What is leverage? What is unequal bargaining power? These are all really big topics, and that is why that is the status quo, is dealing with all of these really big concerns. And so my proposal is to shift toward an area in which we say, yes, these are big issues and they take a lot of time and they are deserving of an entire transactional legal practice. That is what I am advocating for. So this is not a small thing. I recognize that all of these are barriers. And so to overcome that, what I am suggesting are entire practice groups, right? Similar to what we see in litigation practice groups, which frankly also take a lot of time in developing attorney-client relationships, right? Civil discovery takes a long time. Motions practice takes a long time. Getting an opinion from a judge takes a long time. And guess what? The judge might also make a decision that makes you have to go back and rethink about your arguments, and they may have supplemental briefing. So there's an uphill battle in litigation of a whole lot of different issues involving development and permitting and licensing that communities are very much impacted by. And so what I'm saying is let's devote the same amount of resources and energy and attention to a transactional contract side of a legal practice that we do to the litigation, because it's just as deserving. It has just as many issues in the contract law space.
Right, that's a super helpful clarification. And I want to ask, the introduction to your article was written during the Biden administration. It paints a very rosy and optimistic landscape for the prospects of advancing environmental justice. Rosier, let's just say, than we have today in the new administration. Do you want to comment on this change and any implications for your proposal? And I would encourage Maia too to maybe add in whether this changing political landscape has affected SELC's environmental justice priorities and whether it makes the proposal we're talking about today more or less salient.
I actually think the paper is even more important. At this point in time, the paper is fundamentally trying to look at relationships between corporations and communities. And there's some discussion in the paper about how really that is the concept of private ordering. It is really the concept of private sector groups negotiating their own terms, often in the absence of government action, in the absence of court action. And so this is meant to be a tool that can be useful in particular times where you do not have a direct government involvement. Now, certainly direct government involvement can prompt agreements like this. So, for example, in the Biden administration, Department of Energy required community benefits for major energy projects that the department was funding. So that was a huge leverage point and a huge push in the space of renewable energy projects and also carbon removal projects. It remains to be seen at this point in time whether that requirement to have community benefits as a part of DOE funding remains. However, independent of government involvement, I do think that there is still significant opportunity for community benefit agreements in the private law contract space to take fruition. Now, what we see in terms of corporations wanting to come to the table, there's multiple reasons, right? And so I do want to just briefly talk about what we see in terms of leverage. Why would corporations want to come into play? You know, the paper talks at the beginning about corporate ESG, corporate social responsibility, pressure from shareholders, pressure from consumers. So there's pressure points beyond the government that might bring corporations to the table that I do think will still remain despite administration changes. And I do also think basic reduction of risk as a corporate entity comes into a community is another huge leverage point. I mean, many corporate entities understand that if they're setting up shop in a community, it behooves them to get along with the community. And it's not helpful to cite a new project or expand a project when you've got opposition in that local community. That is just good investment. And so I just want to say that I actually think that really getting community benefit agreements and contracts right, and understanding that we need a lot of space to make sure that the practice of contract law develops in the space overlapping environmental justice law is actually extremely important at this point in time.
Thanks, Seema. Really interesting points in particular about how businesses may be viewing their relationships with communities irrespective of what's happening at government level. Maya, do you want to jump in?
Sure. So I guess I'll start by saying SCLC's environmental justice priorities have not changed. We are going to continue to stand with Southern communities for the fact that this administration has abdicated its responsibility to enforce federal environmental laws does not change the fact that everybody deserves to breathe clean air and have access to clean water and live in a thriving community and be free from harmful pollution. And that's not going to change. I do agree that the proposal is more salient in this environment. The fact that the federal government isn't going to do its job really means that environmental organizations and members of the regulatory community need to step up. And so I think it's even more important.
I would like to jump in with one last question. Seema, has your work directing the University of Maryland Environmental Clinic, where law students provide real-world legal services to communities, informed your proposal for nonprofits to establish or bolster transactional practices?
So, as we've discussed, my proposal is really quite large, which is to develop transactional law groups that overlap with environmental justice in environmental nonprofits. And I do think to do that requires a lot of resources for the environmental nonprofits to begin with, which, in my experience, can be helped through law students. A lot of law schools have environmental law clinics. I think there's upwards of 40 across the country with eager law students that are really interested in particular transactional law skills. We often think about environmental law in law school as centered in administrative law, maybe centered in civil procedure and litigation a little bit. We don't always think about it in the frame of transactional and contract and business law. And yet what I'm proposing, I think would spark a lot of interest in students that are interested in those fields and maybe also interested in the frame of social justice more generally and are trying to think about how to pair the two up. And so what my interest has been is really exposing my clinical law students to the experience of using transactional law skills, contract law skills to advance social justice and environmental issues more broadly. And I think there's a real interest in the student bodies that I work with to gain those skills, in addition to actually being able to support and help the environmental nonprofits that do engage more in transactional legal practices. In my experience, it serves two different things. One is to actually support environmental nonprofits in all of the work that it will entail, and it does entail, to work in these contractual spaces, and also as a conduit for new lawyers that might be coming to work at environmental nonprofits, generating interest in working in this space, generating interest in working for environmental nonprofits as students are searching for transactional legal practices.
This has been a really thoughtful discussion, and I think it shows, Seema, that your proposal really is provocative and is obviously worth bringing to practitioners and advocates. So thank you for writing the article. And I'm going to hand it over to Dara to wrap this up.
Well, I'll just close this out here by reiterating my thanks for such an informative episode. What an interesting discussion. I know our listeners will appreciate diving a little more in depth into one of the wonderful ELPAR articles. As we mentioned earlier, Professor Kakade's article was selected for inclusion in ELPAR this year, so please look out for the August issue of the Environmental Law Reporter. You can access the entire top 20 article list on the ELPAR page on the ELI website. Thank you all for being here with us, and see you in the next episode.
Thank you so much, ELPAR, for having me. I really appreciate the comments and thoughtful discussion on my article.
Thank you so much for having me. This has been a very informative discussion.
Thank you for the opportunity to be part of this conversation.
Thanks for listening to People, Places, Planet, the official podcast of the Environmental Law Institute. Our work wouldn't be possible without the support of people like you. If you'd like to learn more about what we do, attend one of our events, or support our work financially, head to eli.org.